In this case, the main question before the court was whether an accused is entitled for statutory bail under 167 clause 2 of CRPC on the ground that cognizance had not been taken before the expiry of 60 days or 90 days, as the case may be, from the date of remand. So let's first analyze section 167. 167 envisages the procedure when the investigation cannot be completed within 24 hours. The clause 1 of 167 says that whenever any person is arrested and detained in custody, and it appears that the investigation cannot be completed within 24 hours, and there are grounds for believing that the accusation or information is well founded, the investigating officer shall forward the accused and the copies of the entries in the case diary to a nearest judicial magistrate. So, if investigation cannot be completed in 24 hours, and the investigating officer believes that the information or accusation is having a solid foundation, then he is obliged to forward the accused to a nearest judicial magistrate. And the magistrate, regardless of jurisdiction, from time to time authorize the detention of the accused in such custody, subject to a maximum limit of 15 days. In such custody means in either in police custody or judicial custody, subject to a maximum limit of 15 days. And if the magistrate has no jurisdiction to try the case or commit it for trial and considers further detention unnecessary, he may order to forward the accused to a magistrate having jurisdiction. And the proviso says that the magistrate has the discretion to authorize the detention of the person otherwise than in police custody beyond a period of 15 days if he is satisfied that adequate grounds exist for doing so. So, a detention can be authorized beyond 15 days, but only in judicial custody and not in police custody, otherwise than in police custody. And the upper limit of such detention is 90 days when investigation relates to an offense punishable with death, imprisonment for life, or imprisonment for a term not less than 10 years. And upper limit is 60 days when the investigation relates to any other offense. And on expiry of such a period, the accused person shall be released on bail if he is prepared to and does furnish bail. And every person released on bail under this subsection shall be deemed to be released under provisions of chapter 33. So, on the plain reading of this section, it is obvious that the right of bail under this section is a mechanical bail, and this is bail based on a deeming fiction in section 167, and it's not based on merits of the case. So it gets automatically unlocked and will be available to the accused after the expiry of the set time period. The accused just need to invoke it just by furnishing bail. No merits of the case will be considered. So the mischief sought to be addressed under this section is the failure to complete the investigation by the investigating agency. So basically, this section is to prompt the investigating agency to complete the investigation. This puts pressure. This is supposed to put pressure on the investigating agency to complete investigation before the prescribed time period. So in this case, as contended by the petitioner, the judgment of Bikram Chand Jain is squarely applicable to these circumstances. The contention of the petitioner in the Bikram Chand Jain case was that he couldn't have been remanded to custody in view of cognizance not being taken for want of sanction within statutory period of 90 days. That is, within the statutory period of 90 days, the cognizance was not taken. The court held that in that case, in Bikram Chand Jain case, the court held that if the investigation is not completed by the investigating agency within the time limit, then an indefeasible right to be granted bail devolves upon the accused. And if he invokes such a right, he should be granted bail compulsorily. But this right accrues to the accused only if the charge sheet is not filed within 60 or 90 days. Therefore, it was observed by the court that filing of charge sheet alone is sufficient to comply with the provisions of Proviso A to 167 clause 2. And it was observed that There is no need to take cognizance within this statutory period. Only filing of charge sheet is necessary. The court in this case, Bikamchand case, explained that during the period of investigation, the accused is under the custody of magistrate before whom the accused is first produced. That magistrate has the discretion to remand the accused in judicial custody or police custody up to a maximum period prescribed by 167 clause 2. And also after filing the charge sheet, this custody continues till the cognizance is taken by another court which is competent to try the matter. After that, the court which has taken cognizance assume the custody of the accused, and it has the power to remand the accused according to the proviso in 309 clause 2. Therefore, the remands mentioned in 167 and 309 operates on different planes. 167 remand is in a pre-cognizance stage, and 309 clause 2 remand is in a post-cognizance stage. Therefore, it is clear from Bikamchand Jain case that case judgment that filing of charge sheet alone is sufficient to comply with the section 167 CRPC, and filing of such charge sheet within the prescribed period will relinquish the right of the accused to obtain the indefeasible bail under 167. And after that, he may apply for a regular bail based on merits, not default bail. And also, the court referred the Muhammad Iqbal, Mother Sheikh, and other. I don't know if the pronunciation is correct. Muhammad Iqbal, Mother Sheikh, and others versus State of Maharashtra. In this case, the accused failed to invoke the right to bail under 167 after the investigating agency failed to file the charge sheet within the prescribed time. And subsequently, the charge sheet was filed, and uh, that after that, the accused tried to invoke the right to bail under 167, but the court declined and held that such a right cannot be enforced after filing of the charge sheet. Hence, in that case also, the court reiterated that once the charge sheet is filed, the right to bail under 167 vanishes totally. This is because 167 is mean to speed up the investigation without latches. Therefore, relying on these judgments, the Supreme Court set aside the order of the High Court granting the default bail in this case. This is the summary of this case. Thank you, sir. That's all.